Hi, Clint Coons here with Anderson Business Advisors, and in this video segment, I'm going to discuss charging order protections. Now, I'm not sure if you're aware of it, but charging order protections is what protects your limited liability company from your personal creditors. Whenever I talk to someone about asset protection, everyone is so focused on inside liability. That is, I'm going to create an LLC and I want to make sure that if something happens with my property that's held inside of the LLC, or if my business is sued, that they can't come after me individually, that I'm protected. Well, all 50 states pretty much provide that form of protection. That is, if you create a limited liability company and a lawsuit develops inside of that LLC, that is, the LLC is the one that creates the harm, then you, as the owner of your limited liability company, assuming you've done everything right and you haven't given the creditor a means to pierce your LLC's veil, will shield you from that liability. And so this is an important aspect of creating LLCs, making sure that we have this liability shield. But what is also equally important is ensuring that the LLC itself cannot be taken because I'm involved in a lawsuit. Most of us do not look at liability protection from the outside very often. What I mean by the outside is that the lawsuit develops as a result of the member's action. It has nothing to do with the assets. You could be driving down the road and you're involved in a car accident and they sue you. There you go. Now you have a judgment against you and they could take your LLC from you potentially in some states. And so when we create these LLCs, we want to be sure that we're creating the LLC in a state that offers charging order protection. Or in the off chance that the LLC you've set up does not offer these charging order protections, as I'm about to explain, then you want to make sure your interest is held by an LLC that offers charging order protections. Because the last thing you want to find yourself in, or the last position that is in a place where someone comes after you and you find out that your LLC will not be protected from your personal creditors. I mean, this is the fact why so many people have gone towards the LLC over traditional corporations, because stock in a corporation is not protected from your personal creditors. So they could take that stock from you and then take your business. In fact, the only state that offers any protection for personal corporations is Nevada. So when we're creating limited liability companies, we want to ensure that they have charging order protections, number one. Number two, you want to make sure that the charging order protections are the sole and exclusive remedy. Now, what does a charging order mean? So I'll first cover that, and then I'm going to talk about why you need it to be the sole and exclusive remedy. So with a charging order, you have a limited liability company here, and you could have several LLCs. It doesn't matter. Well, actually, let's put a few on here. Let's say you had 3 limited liability companies set up, and you're down here as the owner of these LLCs. And a creditor, it's over here. This person here is injured. They broke their leg or something. They fell on one of your properties. They're upset. And they're now going to bring an action against you, and they get a judgment against you for $500,000. So this is above your insurance policy limit. So now there's a judgment entered against you. They then bring you into what is referred to as supplemental proceedings. That's where they get to find out what you own. Up until that time, if they can't discover it through public record search, they're not going to know what you have, because they can't. I mean, they can ask it, but you don't have to divulge it. It's not until someone has a judgment against you can they actually force you to divulge your assets. So here's the case. We have a judgment against you for $500,000. Now we're going to ask you to divulge your assets. So you would tell someone, I own an interest in LLC number 1, 2, and 3. The question then becomes, if I'm a creditor, what can I do with that knowledge? Can I take these LLCs from you? Well, it depends. It depends on the state where the LLC is created and the laws of that jurisdiction. So if this LLC was set up in California, this was set up in Wyoming, and this one was set up in Utah, what could the creditor take? Well, what we want to make sure is that our LLC has charging order protections, that the state statute where you created the LLC offers its charging order protections. Because with a charging order, a creditor is not entitled to take your interest with a charging order. So they cannot take your interest. They can't assume control over your LLC. So they have no control over your limited liability companies. They cannot take your interest from you. They can't force you to issue distributions out of your limited liability company. They cannot dictate how your business is being run. The only thing a creditor is entitled to is any monies that you decide to take out of your LLCs, what we call these distributions. So whenever you issue yourself a distribution, then those distributions of funds, rather than go to you, must go to your creditor until your creditor's judgment against you individually is paid off. Now, sometimes when I tell people this, they think, well, Clint, there's no protection there. I can't take any money out of my LLCs. There's protection here, because just think of it another way. If you didn't have the LLCs with the proper charging order protections, you wouldn't have any assets to even worry about. Here, at least I have control over assets. They didn't take my assets from me, so I still own the assets. I just have an impediment now. I can't take a distribution, because if I take a distribution, it goes to my creditor. Now, there are other ways to pull money out, loans, management fees, and I'm not going to go into that. I'm just discussing charging orders right now. But suffice to say, you can get your assets. You just don't take them out as a distribution. You reclassify it. So you want states that offer charging order protections as a sole remedy so that the creditor can't do anything with your companies. They can't take them from you, can't force you to do anything with them. They're only entitled to the money that you're never going to take out anyways, as long as that charging order attaches. Now, the rub with this type of strategy is that some states do not limit the creditor's rights of recovery strictly to the charging order. Some states allow the creditor to foreclose on your interest. And in my example here, California, Wyoming, and Utah, if you had this structure set up, then what would occur, because Utah and California both permit judicial foreclosure, you would lose both of these limited liability companies to that creditor. That is, the creditor could take your LLCs from you. So now you would be left just with that one Wyoming limited liability company. If you made the mistake and you held an interest in a California or Utah LLC in your own name. Now, before you start thinking of this and going, well, Clint, why don't you just set up another Wyoming LLC and then file it in Utah or file it in California and get those charging order protections that Wyoming has? Well, it doesn't work that way. If I were to create a Wyoming LLC and then register it to do business in California or Utah, then California law or Utah law would apply in the case of me being sued individually. So you can't take the LLC out of Wyoming or Nevada or one of the strong charging order protection jurisdictions and then register it to business in another state and assume those protections will go with you. They do not. They stop at the border. And in fact, there have been many cases on this where people have unwittingly fallen victim to these high pressure or marketing firms out of Nevada, out of Delaware, where they say, set up an entity here and do business in your state and have all these protections. Just doesn't work. The courts instruct people of that when these individuals are sued, and they're oftentimes very upset to find out that they're losing their assets because they didn't understand the way the laws work. And that happens when you're not dealing with a law firm and you end up dealing with just some entity mill that you find on the internet where there really aren't attorneys there, they're just salesmen, and they're willing to tell you anything they need to in order to make a sale. So what I would do then in this type of structure is create your LLCs in these states. So let's say you had to have a Utah LLC because you're doing business in Utah. You own rental property there. And you also needed a California LLC set up because you're doing business in California. You own an apartment building there. Well, how do I then provide protections for me? These charging order protections, if these states, obviously Utah and California, do not offer those. Well, you just don't own the interest in your own name. I never advocate someone own these LLCs in their own name. My strategy requires creating, again, a Nevada or Wyoming LLC right here, and then have that LLC own all of these other LLCs, and then you own this one right here. Now, if a creditor sued you, and I always catch people on this during our asset protection workshops that we teach. We typically teach 2 to 3 a month throughout the United States, and you can find those on our website. But when I bring this question up to the group and I ask them, how many LLCs that you own? Now, a lot of people miss this. They look at this structure and they'll give me this number. They'll say, Clint, I own 4 LLCs. Reality is, you don't own 4 LLCs. You control 4 limited liability companies. You own 1 limited liability company. That's all you own right there. So your creditor would just focus on this one Wyoming LLC. Wyoming offers great charging order protections. It's one of the few states whose law holds that a creditor's right against a member is limited solely to a charging order. That's it. So if they sued you and they get a judgment against you, the only remedy they have is a charging order. Nothing else is available to them. So in this particular case, my creditor again, who is over here with that $500,000 judgment, then his claim against me is only going to be limited to if I ever pull money out. The other benefit of having this form of structure when it comes to charging order protections is that you can now take distributions from this company down to here, up to here, down to here, down to here, down to here, just like this. All day long, your business can continue to run, and none of it's considered a distribution to you because you're not taking the money out. You're keeping it with this blocker entity. Having a Wyoming or Nevada blocker entity is the key to any proper foundation when it comes to asset protection. Because of the great charging order protections and anonymity that these entities provide, we typically recommend that our clients begin with this blocker entity because it's going to give them flexibility in the future should anything happen. And one last item of note is that when you create structures like this, and take it from someone who's been doing it for 19 years, and you're sued individually, you're not going to get to this point. Creditors end up walking away and they do not bother with the charging orders. If they know that they cannot get the money, they can't foreclose on your LLC, they're not coming after you. They're going to settle, take the insurance, and then disappear. It's only when you have these LLCs in Utah and California and other states that do not offer charging order protections that I find creditors move ahead with the case and they move ahead to foreclose on the individual's interests. And so there's a real difference when it comes to creating these entities, knowing that you need to set it up in the right state, and more importantly, you have to have an operating agreement that provides the type of protections I'm talking to. A lot of people create LLCs and they may put them together in the right state, Wyoming or Nevada, but at the end of the day, turns out that their operating agreement is going to do them harm because of the way it's drafted, that it forces them to take money and they don't realize this. And so a creditor comes along and sues you. Yes, they may be limited just to the charging order, but your operating agreement says you have to pull money out every year. So they're going to get paid every year and then they're happy. They don't care. So they'll proceed against you in those instances. So you have to make sure you're working with someone who understands the nuances of these agreements as well. At Anderson, that is what we do. Be sure to check the notes down below this video. I've listed out those states that you should avoid owning an interest in a limited liability company. I call these the weak states, the states that do not offer strong charging order protections. I've also given you a list of states that have very strong charging order protections and ones in which if you did own an interest there, you would have protection. But just because it offers charging order protection, you're going to see in that list, it doesn't necessarily mean that that's the right strategy for you. Because at the end of the day, don't put yourself in a situation where if I sued you, for instance, in Oklahoma, and you have an LLC there, and yes, it offers charging order protection, but it's real simple for me to take this judgment now that I obtained in Oklahoma and then register it against that LLC immediately. Create another roadblock. Create a blocker entity in Wyoming or Nevada and force creditors now to have to go and hire an attorney in another state. Because the key here is that when it comes to a judgment creditor, what you want to do is make the bar so cost prohibitive to them to go beyond your insurance premiums that they just decide they're going to walk away because they don't want to fund it themselves any longer. That it's become too expensive to go after this money, which at the end of the day, because of the way we've structured you, they're not going to receive anything anyways. That's what we do at Anderson. My name's Clint Coons with Anderson Business Advisors.